Good day. Today I'll be discussing the reported charges filed by the Department of State Services against Mallam Nasir El-Rufai before the Federal High Court, Abuja. Now, according to the charge sheet circulating publicly, the Federal Republic of Nigeria alleges 3 major counts against him. Count 1 alleges that during an appearance on Arise TV on the 13th of February 2026, he admitted that he and others unlawfully intercepted the phone communications of the National Security Advisor, Nuhu Ribadu. The prosecution says this act violates Section 12, subsection 1 of the Cybercrimes Prevention Amendment Act 2024. Now, this section 12 of the Act, generally criminalizes the unlawful interception of electronic communications. In simple terms, if a person intentionally intercepts private communications without lawful authority, that conduct may amount to an offense under the law. Now, count 2 appears to allege that he acknowledged knowledge of an individual who carried out the interception but failed to report that person to the relevant security agencies. This is also tied to the provision under sections of the Cybercrime Act. Now, the legal question here would be whether mere knowledge without reporting satisfied the elements of offense as defined by statute. Count 3 refers to Section 131, subsection 2 of the Nigerian Communications Act 2003. That section addresses the unlawful use of telecommunications equipment in a manner that compromises national security or public safety. Now, the prosecution is essentially arguing that the alleged interception created insecurity and threatened national security. Now, from a strictly legal perspective, 3 key issues arise. First, was there an actual unlawful interception, or were the statements made during an interview taken out of context? Second, can statements made during a media interview amount to an admission sufficient to ground criminal liability? Third, did the prosecution properly establish jurisdiction and the required intentions, of course, which is the mens rea and the actus reus? It is important to remember that under the Nigerian criminal law, every accused person is presumed innocent until proven guilty. Now, and this has to be proven beyond reasonable doubt. Now, the burden of proof rests entirely on the prosecution. The case, if it's formally prosecuted, will likely test the interpretation of the Cybercrimes Amendment Act 2024 and the scope of national security protection under the telecommunications law. As always, the courts will be the final arbiters of both the facts and the law. But then we want to hear from you. What do you think? What is your take? Are they likely to succeed? Drop your comments.